This is Gnostic Media Research and Publishing's podcast episode number 159. I'm your host, Jan Irvin. This episode is an interview with Freeman, Burt, and Clint Richardson titled The Court, Clerk, and the Court of Record, and is being released on Thursday, March 14, 2013. This interview with Clint and Burt was recorded today, Thursday, March 14, 2013. Freeman Burt is a man who lives under the belief that all people are born free and that no one can be required to become someone's servant. He's almost 50 years old and has been studying the elements of freedom for about 20 years. Most of his gain in comprehension came when he fully accepted the fact that all legal relations require our consent. From that point of view, it became easier to accept the truth that the legal law is correct. He is not claiming that it is right or moral, just that it is correct in its application. The more time he spent reading the actual statutes, codes, and ordinances and legal dictionaries, the more he's learning that we are in fact free and that we volunteer into servitude. Freedom is a voyage with no predetermined destination because such destination does not exist. As long as there are slaves in the world, we ourselves can never be free. And Clint Richardson is back for his sixth time, and I'll spare everyone the introduction. If they want to hear that, they can hear the very last episode, and I will post the notes about Clint up on the website to this episode. And I mention again, the new Gnostic Media bookmarks with the fallacies on the back are up on the Gnostic Media website, available by 3 or in a dozen. And just a reminder, Joe Atwill and Jay Fikes and I are working on a project on mind control. I will keep everybody posted as more comes up on that. And donations. This episode is dedicated to David, Samuel, Scott, Tad, Janet, John, Paul, Max, Joseph, Oscar, Stephen ×2, and actually David made 2 donations also, Aaron, Randy, Lewis, and Carlos. And thanks to all of you, without which this episode would not be possible. It's greatly appreciated. And we do our best to provide just about everything here for free, so your donations and website purchases are greatly appreciated, so thanks so much. And the show is run on donations on our website sales. This is not corporate media, but independent media in the true sense of the words. By donating or ordering one of the books or a DVD or the SWR archives, a shirt, the bookmarks, a membership to the website, etc., you help to continue this unprogramming. And before I forget, the Gnostic Media first 4 years are available up on the website on DVD, so you don't have to spend hours downloading them. It's about 280 hours of audio or something like that. It's quite a bit. The views expressed by the authors and guests of this unprogram are their own and are not necessarily those held by myself, the host, or Gnostic Media. You can check out the website at www.gnosticmedia.com. That's GNOSTIC media.com. You can reach me directly at contact@gnosticmedia.com. Thanks for listening, and thank you for your support. And here is my conversation or interview with Clint and Burt, the Court, Clerk, and the Court of Record. Enjoy. Everyone, welcome to the Gnostic Media Podcast. I'm here with Freeman Burt, and Clint Richardson is back again. And, why don't we, most of you know who I am, since this is the Gnostic Media Podcast. I'm Jan Irvin. I'm the host. Clint, why don't you introduce yourself here quickly?
Sure. I'm Clint Richardson. My websites are realityblogger.wordpress.com, where I keep all of my research, and my movies are located at thecorporationnation.com. Burt from Colorado is a very interesting character that I have known for quite some time now, and we constantly are in back and forth conversations about legal and lawful stuff. And he was very anxious to talk about what he's found, and he's been an invaluable tool for a lot of my comprehension on how things work. He is, of course, way more focused on the subject of the legal system than most of us, and he pretty much hovers in that realm, which is great because it makes him, an invaluable tool when it comes to his research that he's doing. And as I was talking to Burt today, I realized that what he was saying needs to be needs to go out to everybody who's trying to survive in this system and probably doing it wrong, including myself, after listening to Burt. So I invited him to have I actually invited you, since you have the recording equipment, to hopefully get this out there, and hopefully it'll help some people understand what they've been doing wrong in the court system and what they can do to further their efforts. So Burt, why don't you introduce yourself?
Well, hi there, folks. Like I was trying to say earlier, that I am just basically an everyday guy who just simply started researching this whole legal nightmare. And most people have a specific thing that basically pushes them over the edge to begin this type of research. And mine started with the income tax. And after researching the income tax and figuring out that that's actually a hoax, then I said, well, what else is a hoax? And that just led me to where I am now. And what I'm finding out is that the entire legal court system is nothing but a giant trap. And the real court that is actually existing behind the smoking mirrors of the legal system, it's actually there. It's just that we don't know how to access it. And hopefully that's what we'll be able to touch on today, to give the people at least a glimpse of what the reality is. And there's no way from the information that we're going to get across today is going to be enough to allow anyone to actually go out there and practice this, but it will give them at least a hint so that they will try to research and learn more about this.
And you'll be giving all of the places to go and research and what they need to understand, right?
Well, I'm actually offering also some lessons for people that want to learn the concept, because what I'm finding out is that if you don't have the basic concept about freedom, none of this stuff will make any sense.
Now, just to lend a little credibility to yourself, Burt, make sure that we're not, just so people know, we're not just talking to some guy who's, doing a little basement research. You have been and are currently helping other people in the legal realm. Why don't you tell us a little bit about some of the services that you offer to people, just so that we know that you are legitimately pursuing this?
Yeah, well, I mean, I have people from all different walks of life that come to me wanting to fight a particular battle, and they don't want to do it with an attorney, and they want to stand on their own 2 feet, and they want to learn in the process. Now, sometimes you can take on a battle and lose, but even though you lose, you learn an immense amount of information. Because when you take on an attorney, the attorney just simply takes your case, does his little magic, pull a rabbit out of the hat or whatever, and you never learn anything.
It's true, and you'll find that a lot of people who have pursued law on their own 2 feet have had to go to jail for it. That's a very common. I mean, we could take Larkin Rose as a very good example of that. How to learn? You really have to get your butt kicked before you can learn.
Yes, and that's what I'm trying to do for people, is that the lessons that you are going to learn by tackling this thing on your own are invaluable. And some of the things you are going to learn by going to court and trying to stand up on your own 2 feet, you are not going to find in any book. Because some of the things that I'm actually learning, I haven't found written anywhere. And even if you go through the statutes, like Clint and I have lots of information about this, you sometimes have to actually connect one statute from one code to one way on another title, right, Clint?
Absolutely.
In order to get the full picture. So what we can do with this thing is I can just kind of give a basic example of a case. Maybe this will be even better than what we did earlier, Clint.
Well, I'd like you to just start again, where you started with me, knowing that I knew most of the answers to your questions, Jan and the audience perhaps might not. And so I'd like for Jan to chime in whenever he's unsure of some of the facts that you state, to point to the final area where you're trying to get.
What I'd like to do, though, Clint, is have you direct the conversation so that you make sure that he gets the most out, since this is my first on it.
Absolutely. So, Burt, before we do that, before we go to the case, unless you think that's a better learning tool, I would really like to start where we started before.
Okay, and now I don't quite remember where we started.
That's what I was afraid of. But okay, so the basic subject today is for people to understand, one, that we have two separate types of legal systems here. We have one that is for the people and one that is basically to make profit from the people. We have a court of equity, we have a court of record. And what we're going to be talking about today is how to avoid being caught up in the court that you don't want to be caught up in. And it's very important to understand, when people go to file things, we have to understand what is the most important office that is held within the court system. And we're talking about every court system here. So, Burt, what are you having your clients do now when they file a case or when they reply to a case?
Yeah, well, this is the most important thing whenever either a corporation or a municipality corporation, which could either be the state, the United States, or Walmart, coming after you, is that you must counterclaim. That is the most important thing. If you do not counterclaim, then you are accepting your opponent's case on its merits.
And this would include divorce cases.
This would include anything, any case, anyone that brings a case against you. If you do not counterclaim it and you try to take a defensive position, when you're acting as a defendant, you're actually limiting your ability to present a case, because now your defense is restricted to your opponent's case.
And to give you an example of how that can work, I can start a dummy corporation that has absolutely no relevance to anything, and I can send you, Jan, I can send you a letter, a certified, notarized letter in the mail that says you owe me $150 in debt. Okay, it doesn't have to be derived from anything. I'm only sending you a letter that says that you owe me that. That, when you accept that by not responding to that letter, then you've accepted that within, say, 28 days. You've accepted that as a legal contract, a binding contract that says that you owe $150 in debt. It's that simple. And this is basically what the IRS is doing. This is basically what any government agency is doing, is justifying a tyranny, a debt, where there really isn't one. And it's maybe going a little too far, but it's as simple as making an offer through a legal notice, and then you accepting that offer. Everything is an offer by non-response. In other words, your silence to that or your non-responsiveness is your consent to that claim or that offer.
Yes, so then what would be your options? Your options would be to pay the $150 or counterclaim it. So, and then that's where what I'm going to say here, Aaron, you can counterclaim it. Now, when you counterclaim it and you go to the court, that's where basically the battle begins. Most people believe, or are under the belief, that your battle is in the courtroom, like in front of a judge or a magistrate. But that's actually not true. Your battle, your most important battle in court, begins at the court clerk's office. And this is what I'm like so excited about, because when you go to court, and this will make little sense to people who actually have not been to court, and that's why in the classes that I'm trying to teach people, I have a lot of crucial homework for them to follow in order to be able to comprehend this. But when you go to any court okay, you usually are going to see several clerks running around, okay? All those clerks running around are not the quote-unquote court clerk. Every court has only one court clerk. All the other clerks are what they refer to as like clerks of the court. And I sent some information to Clint and other people about the importance of the word of. It's a very little word, but very powerful. The word OF means belonging to, being part of, or being under the control of something or someone.
And just to give an example of how important these little connecting words are, remember Bill Clinton when he said, well, it depends what you mean, the definition of is, right? That little word is means so much in the legal realm. And so when we attach the word of to connecting two different things, it's a very important distinction. So go on, Burt.
Yeah, like for example, the clerk of the court of record, or the court of record clerk, is talking about a clerk that is related to this court that maintains some kind of a record. But when you say a clerk of the court, you're talking about a clerk belonging to, and if you look up the definition of court, it also means judge. So you're talking about a clerk of a judge. And that is a huge difference. Okay.
So basically, the secretary of the judge is the clerk of the court. So what's the difference between the clerk of the court, the secretary of the judge, and the court clerk?
Yeah. See, the court clerk, when you look at a court building, okay, and you know there's people working in there that are supposed to be dealing justice. The most important officer in that entire building is actually the court clerk. There's no one more important than the court clerk.
More important than the judge?
More important than the judge, more important than anyone in there. And one way that highlights this is the officer in that court that has the highest bond is, in fact, the court clerk. Everybody else only needs to maintain a $5,000 bond, and the
officer, as in what type of officer?
Well, anyone that works in that court is considered an officer. Okay, so, or an employee, I mean, whatever you want to call them, but technically they're all officers. So anyone working in there has some kind of a bond, and most of the people working in there only need to maintain either a $3,000 bond or a $5,000 bond. And the clerk has to maintain $100,000 or bigger bond.
Why don't you explain to people what a bond actually is when we're talking about a bonded official like this, officer?
Yeah, well, the bond just works like an insurance, kind of like if you have renter's insurance and you live on the third floor. If your kid happens to leave the faucet running, and that water drips all the way down to the first floor, you're going to cause all kind of damage. So your renter's insurance covers that possible damage. Well, the bond covers the damage that clerk might do to you. Of course, $100,000 doesn't go very, very far, but it still, might cover, a very basic error on the part of the clerk that caused you some kind of damage.
Well, it's also, I think, important to note that if your bond gets tacked, if it gets taken, then you can no longer operate as a public official.
Yes, and then this is the other funny thing, is that we've all heard that judges are immune from counterclaim or for being claimed or whatever. The clerk is not. The clerk is completely open to being sued.
So while we're all focused on the judge as being this focal point of the court, we never realize that the court clerk, not the clerk of the court, but the court clerk, in that word magic, is the focal point of the court. It is basically the librarian of the court. It is in charge of keeping the records of the court. But it also has a very, what surprised me, it has a very, very, very important other distinction, which is to settle or to create default judgment. So in other words, we all think that the judge of the court is the only one that can, say, issue a warrant and sign it, or bring the close to a case because another party never responded to the legal demands or notices of the case. And yet we don't even need to go to court for that. We can go to the court clerk and demand it. And apparently it is the requirement by law of the court clerk to issue that default judgment. Is that correct?
Yeah. And I mean, I was so excited when I actually found the statute in the Colorado legal law that I was like, because the way I operate is kind of like a hound dog. I smell something and I'm like, okay, there's got to be something to this smell. and I just keep following it, and then I try to find the evidence that backs up what I say. And right now I'm in the process of finding more evidence in the system to back up all of these things that I'm basically unraveling here. And some of the things that I'm unraveling, there's actually no statute that makes it very clear. There's just little pieces of it, and then you have to put them together. Like, one thing that's very important, when you file a case in a court, okay, they are going to give you a timestamp saying that you filed that case. And a timestamp is no different than the timestamp that you could get at McDonald's or Burger King or any other place. It's just a timestamp. But if you want to file your case with the court clerk, which actually is the only court that handles what is known as the court of record. And if you look in the statutes of any state, they're going to tell you that there is such a thing as a court of record. Now, all courts are not court of record. For example, a traffic court, that is not a court of record. That is just simply an administrative court. And in most states, the court of record is actually the third court from the top. Every state has a Supreme Court, which is nothing more than an appellate court, an administrative court. And then you have the appellate court. And then the third court from the top, that's usually the one that you want to be in. And one way that you can recognize the proper court of record is because a court of record does not have a limit on the amount of remedy that it can award. Lower courts have either a $10,000, $15,000, or $25,000 limit, and that's across the 50 states united. And so that's one way to realize what it is. So the point is, you have a case. If you bring it into the court and you don't know the difference between the clerks of the court and the court clerk, the clerk that usually 99.999% of the time that's going to come to the window is going to be a clerk of the court or one of the clerks of the judges. They're going to take your case and they're going to say, oh, you have a problem with Clint or Yan. Okay, well, let's see, who's the next judge on the roster? Oh, it's this judge here. Okay, well, we'll set your case to go with this judge here. And guess what? They just took your case and then just entered it into the legal court.
Now, to put this into perspective, when you say that you know, basically what we do is we go into the court, we go up to a window, we have no special ins or you know, like an attorney or a judge might. We go up to a window and we basically talk to the minion. We talk to the lowest level form of clerk, which generally I've found to be a very uneducated, someone who speaks perhaps Eubonics. You know, it's basically the DMV, the same person that works at the DMV window, someone who really has no idea in the tyranny and criminal pursuits that they're participating in and that's employing them. They're basically grunts. And on that note, when we're talking about the court clerks to all of these other clerks, we're talking about the most important piece of the puzzle, the most important person. You can't just become a court clerk by you know, affirmative action. you have to really be in the know and know what's going on to be a court clerk. And this is why, as Burt was explaining to me, you'll never ever talk to a court clerk unless you specifically demand to have your case or whatever you're filing put on the or in the court of record. Now, at this point, I think it's really important to make the distinction between what the court of record is and what all of this other legal mumbo jumbo is that we call the court of equity or the court of appellates and the court of what is so important about the court of record as far as the artificiality of it all.
Well, the most important thing about the court of record is that is the one place where you can actually stand as a real man. In all the other courts, you can only stand in as a fictional entity.
A person.
As a person. And the other part that is very crucial about the court of record is that the fictional entities cannot really stand in a court of record because they can only exist in the legal court. So when you
so what you're saying is if you file or respond to a case using the court of record and standing as a man or as a human, then a fictional corporate character cannot come back and respond on that level.
Exactly, because then the only way that they can actually respond to you, which all fictional entities, corporations, they have what? Attorneys, right? So the attorneys is the face, is the body for the fictional entity. So if an attorney shows up in your court, then guess what you're going to do? You're going to say, "Oh, I recognize you now as my defendant. You are now who my case is up against because you're the only human body standing in here. So I'm putting all the liability on you."
So you're saying that an attorney, being a legal fiction, cannot actually stand in a court of record?
No, because the only way he can stand there is if he's willing to take the liability.
So the goal of the court system and the way it's set up now is, of course, to herd everyone like sheep into the court of equity,
right,
into
and to pay a lawyer, etc. So then you're trapped into that whole thing.
Well, and that's the most important thing that I think Burt was talking about was let's get into now that we understand that the court of record is for men, or as you call yourself, a free man. When we go to court, we're expected to pay fees. We're expected to hand over money. What is the significance of that?
Oh, this is so huge. This is so huge, and I mean this. Again, some of this stuff that I end up figuring out, I always bounce it off other people that I consider smarter than me, like Clint. And just to make sure I'm not, losing my mind. And I've actually confirmed this with a few other people, and they went out and did some additional research. And this is what this other fellow that I know did some research, and this is in another state, okay, not Colorado. And what he came to find out is that when you pay a fee to file your case, and the fees vary, okay, and it varies from court to court. Some courts will cost you to pay a fee depending on the value of your case. So if you have $1 million case, you may have to pay $600 filing fee. If you have a $100 case, then you might only have to pay $30. So that didn't make sense to me. So I started thinking about this, and I'm like, well, whenever you go into the legal court, they always try to get you to play the role of pro se. And pro se means that you're representing yourself, which means you're acting as your own attorney.
Yeah, and that's very important to understand the difference between actually standing up as a man on your own 2 feet and actually the difference between that and acting pro se, which is actually acting as your own attorney. So you're actually almost taking on an artificial state to represent yourself, whereas standing up in the court of record is not that. It's actually standing up as yourself.
Yeah, and the reason that they want you to act pro se is because now that you're acting as an attorney, and attorneys, in fact, are using the courts for business. They are acting no different than you getting in a big old 18-wheeler and using the open highway for commercial purpose. So the attorneys are using the courts for commercial purpose. So it would only make sense that they should be charged with paying a fee for operating within the court.
And that is to also say that when you go to court, you're acting completely in commerce as well when you're going to the equity courts,
yes,
as opposed to a court of record.
Yes. And this one friend of mine that did a little more research, he actually found a legislative act that broke down what you're actually paying for when you pay a fee for filing your case. And one of the interesting things that he found, it was actually like 8 or 9 different things that were included in that fee. And one of them was you are actually paying for the raises that the judges receive. Okay, so you're actually paying for the increase in salary to the judges when you pay your fee. Now, what really shocked him was that if you were to go file your case and they said, well, this $100 that you're paying is going to be for this. $10 is for the judges, $10 is for the water cooler, $10 is for this, $10 is for the other thing. You would be like, wait a minute, what are you talking about? I'm having to pay all this nonsense stuff just to make use of the court? You would go berserk. So they hide it by calling it a filing fee.
Mm.
And if you look up again, this is all legal terms. If you look up the definition of a fee is basically either a tax or is a payment that you are paying for in exchange for a service.
So, in other words, when you're paying to use the courts, it's no different than paying to use, say, a gym membership.
Exactly.
So, what is the difference? And that is all happening in the court of equity. In other words, that's all happening in the straw man realm, the legal realm. Do you have to pay those fees in the natural realm when you're going to a court of record?
Well, and that's the funny thing, because if you look at the history of court clerks, okay, you will find out that what they actually used to do a long time ago is that whatever the controversy was that was going to be before the court, the clerk would receive a percentage of the winnings. You know, whoever won would pay the clerk a percentage, a small percentage. And then that would pay for the salary to the clerk and for maintaining the building and paying the judges and paying the magistrates. The clerk is the one who would pay the judges and the magistrates. Okay, and that's why the clerk was, in fact, the most important officer, because judges and magistrates would come and go. But the clerk was always constant, because they're the ones who actually knew how to run the court and actually knew their stuff, compared to everybody else. So anyway, the trick getting you to pay a fee is because they're getting you to buy the services of a judge. So you pay the fee, and now you just bought yourself into some judge's courtroom.
You've actually paid for a service as opposed to, in other words, you've accepted a contractual obligation to participate in that service.
Yes. And when you go into the court of record, the only one that can ask you to pay anything would have to be the court clerk. The court clerk would actually have to give you some kind of an invoice. And it's either going to be a set amount or it's going to be a percentage. Now, what my friend found is that, guess what the amount? Just take a wild guess. This is in Virginia. What it actually costs to file a case in the proper court.
What, $1, $10?
You were very close, $2.
Well, that according to the consummate Constitution is a fair and just fee.
Exactly.
Correct. So really, there is no fee to there are no service charges, I guess would be a more correct term, to file or to participate in the legal system. And I think that's the distinction we're trying to make here, is that the court of record is like the de jure form of court in the United States, just like the de jure form, or the republics that are the states, are the de jure form of government in the United States. But what we've all been tricked into doing is voluntarily, through coercion, of course, but still voluntarily and with our ignorance as our consent, is to participate in this legal system where we pay for our own servitude, basically, through these services. And by doing so, we're contracting in a way that we don't understand to be part of that system, when the whole time we have this de jure, wonderful, if you will, constitutional, although I hate to say that word, form of court that we can utilize that won't even allow attorneys, per se, because attorneys are fictional entities. So we have this at our disposal, but we don't know how to access it.
Yeah, and an attorney will never tell you that.
No.
Well, now, what about Canada and England and other countries? I mean, this podcast is going to be going out everywhere.
It operates anywhere that used to be an English colony.
Yeah, and I think the word chancery, which is still utilized in England, I think is the word equity in the United States. You'll have to verify that, but that's what it looks like to me, that we got rid of the chancery. I mean, we basically just took the old English Roman law system and transferred it into America. It's really not that much different. Only the words changed. So chancery, I believe, became equity, if I'm not mistaken.
Yeah, so the same rule would apply in Canada or in England. Basically, you just need to find out which is the proper court, and then that's where you would go and file your case. Now, using an example of, let's say, like a traffic ticket, the mistake that most people do when they receive a traffic ticket is they go to the traffic court and they start arguing whether they were going 55 or 56 or 58. Okay, that's irrelevant. The fact that you're there to argue the summons or the ticket, you are legitimizing their accusation. And you're standing as a defendant.
You're standing pro se, essentially.
And you're standing pro se.
Artificially.
Now, the problem, like I said earlier, with standing as a defendant is that your defense is restricted to what your opponent is talking about. That's why patriots go to court and they try to argue the Constitution, they try to argue this other law, blah, 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 and the judge says, man, if you keep arguing that, I'm going to throw you in jail for 3 days. The Constitution is irrelevant in this court, and people don't understand what that means.
Well, I think that's an important thing. Let's discuss the difference between how a magistrate court works and how a regular...
Yeah, and to reemphasize, and we talked about this last time, Clint, and from my interview with Jose Barrera a couple of months back, he points out that the word magistrate actually comes from magi, or magician, and in the British courts, they actually dress exactly the same as the old Egyptian magi.
Absolutely. Okay. But the difference between these two, though, is very important when you're actually participating in this system, in the legal part of this system. I think you have to understand the difference between a magistrate and a judge, and the difference between arguing or presenting a law or a rebuttal of a law or a presumption in those two different formats. And Burt can explain that better.
Yeah, now this is from your point of view as a man or a woman, wanting real, quote-unquote, justice, right? You would not want to go ever before a judge. And I've had a hard time explaining this to people that are involved in family court, because every time you go to family court, you're always going to be before a magistrate. Now, what you just said about magic and all that kind of stuff, that doesn't really apply. The purpose of a magistrate, as opposed to a judge, like in family court, the magistrate is not restricted by statutes. He can operate within and without the statutes. The judge is restricted to statutes. So if you bring a family matter, which, as you know, has immense possibilities of outcome, if you bring that type of a scenario in front of a judge, then the judge is going to have to take your situation and somehow force it to fit within some statute, as opposed to going before a magistrate who can say, well, there is no statute related to your problem, so we're going to create new law here.
Yeah, and I guess the other aspect of this is that if you go in front of a judge and you try to present a law and say, look, judge, this law in this book says that what I did is perfectly legal, the judge is not necessarily required to utilize that law. Yes, there's a law on the books, but it doesn't necessarily mean that the judge has to use it in the case. If you want that law to specifically be within your personal case, you actually have to step outside of that court and go back to the magistrate and introduce that law into the court, if I'm not mistaken, so that it will be recognized without dispute in the next court, which is of the judge, where the sentencing happens.
Well, but now we're kind of going a little bit into a tangent. But the point that I was bringing about the traffic scenario is that if you go into the traffic court, you're screwing yourself without even knowing it. Okay, so what you want to do is counterclaim that policeman and the people that he represents. So the traffic court usually has a very low amount of money that they can award. They have like the lowest amount. So you simply, if that court has a $15,000 limit, then you counterclaim for $16,000. And then that automatically takes it out of that court and brings it up to the next court, which is where you want to be. And then you serve your counterclaim to that policeman, to the clerk of that particular court, and then you present it to the court clerk in the higher court. Now that policeman is going to be liable to you and the corporation that he represents.
And I think it's important to note here that you're not necessarily, when you do these type of things with counterclaims and such, you're not necessarily attempting to exact that money through the court, through the system. You're simply defending yourself, and your real goal is to get the whole case dismissed.
Well, or it might be to actually get remedy.
Well, unless you're seeking remedy, yeah.
Yeah, because let's play a scenario. And like I told Clint earlier, I'm walking down the street, and all of a sudden Clint comes out to me and says, hey, give me your wallet or I'm going to break your nose. I'm like, okay, man, take my wallet. So he takes my wallet and pulls whatever value I have in there and gives it back to me, and then says, and by the way, here's a summons for you to go to court because you in fact didn't have enough money in your wallet for me. Okay, so we go to court. Now, would it not seem stupid for me to go there and argue the fact that I didn't have enough money in my wallet? It wouldn't make any sense. This wouldn't make any sense. So what would make more sense is for me to counterclaim and say, in fact, Clint didn't have the authority to ask me for my wallet, and in fact, his act caused me so much stress, caused me so much problem that I think it's worth $20,000.
So are you saying that you would do this to a police officer who pulled you over to the side of the road illegally, using emergency lights illegally because there was no emergency?
Exactly. And by doing that, I mean, if a man wants to stand free and he doesn't want the cop to bother him, there's no better way to do it than countersuing. Because now that cop is going to have to defend himself to you personally.
Now, here's my question. When you are doing this, because the court is originating in this court, this equity court, this fictional realm, are you filing this in the court of record? So I guess my question is, obviously this court of record is the standing court. What's the jurisdictional authority? In other words, is this court higher or lower than any other fictional court?
It's the highest court of the land.
The court of record.
Yes, that is the true court.
That is the true court. And what
There is no higher court.
So it almost sounds like what we're doing is, when we talked about this also last time, Jan, when you sign that end user agreement for Microsoft, when you get your shiny new computer, you're excited to use it, so you don't read your end user agreement. But within the end user agreement, it says that you agree to arbitration. Basically, you'll give up all your constitutional and any other form of political rights, and you will agree to arbitration with a set company that Microsoft will decide, and that arbitrator will decide what is justice. That's essentially what is happening when we agree to these types of tickets that officers of the municipal corporation, they're no different than any other thug coming up to us and stealing our wallet. They're just doing it in an official capacity, of which you have to counter. In other words, it sounds like that's what you're saying is that we are just being fooled into going into a mediation type of court, which is the legal realm where we're allowing a judge to decide our fate, as opposed to standing up for ourselves in the court of record.
Or in the case of divorce court, you're allowing the mediator, her or himself, to decide the fate of your family and things. And, I had a mediator a couple of years ago who basically ignored everything I said and decided that all of the crap that my ex made up right when she walked in was true. And everything that I said, even though I had it documented, she refused to look at the documents and decided that what I said was false.
Well, did you counterclaim in that situation or no?
I did file a counterclaim, but not. I filed a 6-page counter thing, which was probably only what got me through it, but nothing like you're suggesting here. That's for sure.
Yeah, and that's, a mediator, and that's of course we're not kind of going into a tangent, but if someone is going to mediate a situation for you, you have the right to provide the mediator with the perimeters within which that mediator is going to operate on. Because if you don't, then you're giving him basically the power of God.
Would you repeat that again, please?
That when you accept a mediator to mediate your particular problem, if you do not restrict or put boundaries.
So how would you go forward in a case like that in a divorce court where they corral everybody through the mediator and all this crap? How do you get around all of that?
Well, both parties must agree to a mediator before the mediator is assigned.
Yeah, this is a very important thing. Everything
so if I didn't agree to that crazy psychotic woman, I wouldn't have had to have defended myself against her nonsense for 6 months afterward.
Exactly.
Because everybody that goes to jail is doing so voluntarily. Everything that happens in the court of equity, in this fictional realm, it's a voluntary agreement. Again, you're paying for the service to be put in jail.
Yeah, you pay for a mediator.
You're paying for these services. This is the difference between the court of record, which is the court of man, and the court of equity, which is the
So let's say you want to get a divorce, or and I didn't want to pay the $400, and like a fool, I let her file first, so then I had to file a counterclaim. Now, so if you wanted to get a divorce, otherwise you would just go to the court of records and file your divorce there rather than to the lower place, correct?
Okay. Well, this is how it would work, and this is the beauty about using the proper court is that you present your case, okay, which would be your counterclaim or your initial suit, okay, if you're the one initiating the suit. Now, you're going to serve your opponent, and you're going to give him 21 days to respond. If your opponent does not respond, then that means, and you have evidence that you served them with the paperwork, then it means that they agreed with your case. They defaulted, right?
And then that's it.
And then that's it. You won.
You've won the case outside of court, and this gets back to the clerk's job. And Burt sent me the Colorado statutes that I'm going to read right now so that you understand how this can be done. A lot of people always operate outside of the court system, never setting foot in a court and get all these things accomplished. So here's what it says about the clerk's office, the court clerk. Clerk's office and orders by clerk. The clerk's office...
Okay, pause right there. You see, it says orders by clerk. It's telling you right there that the clerk can issue orders. Most people think only the judge can do that.
Yeah. The clerk's office, with the clerk or a deputy in attendance, shall be open to such hours and on such days as may be provided by law and by local rule not in conflict with law. All motions and applications in the clerk's office for issuing process, for entering defaults or judgments by default.
Okay, pause right there. There is judgments by default. So your clerk can enter judgments by default.
Right, and this is saying all motions and applications in the clerk's office for issuing process. That's a very important term because process is, you're talking about due process. This is due process.
Okay. So what about a child custody case? How would you handle this?
It's all the same thing.
It's all the same thing. The problem with child custody is that you're voluntarily allowing your children to be property of the state when you enter into the court system. I wrote extensively on that, pulled up a bunch of court cases and decisions that stated specifically that the court owns your children.
So now what if you're in that situation? Is there any way to go through the court clerk to undo that?
Yeah, now see this, and Clerk Clint and I already were discussing this because he was asking me, so, well, Burt, what if a case in the legal system makes its way all the way up to the Supreme Court of the state? Can it be overridden in the court of record? And my answer is, of course. Because Supreme Court, what do they issue?
Opinions. Oh, you know what opinions are like, right?
They're all legal interpretations. If you don't like it, then go file a real case in a real court.
So let's say, wait, let me ask you though, excuse me, Clint. So let's say you have, a 50-50, custody battle with somebody who does less than reputable things the other half of the time with the child. Is there a way that how would you go to the court of record and switch it so that you would say have 100% custody?
Okay, and this is the thing. Now, going through the court of record, if you are fighting a fictional entity, you actually have the advantage, okay? Because a fictional entity is fictional. There's the fictional entity cannot defend itself against your accusation, okay? Now,
right, it's like the ghost in the green fairy in the corner there to defend itself. So then you win by default, right?
Yes, exactly. But if you're talking about a man and a woman, well, now you're talking about two real people.
Okay.
Okay. Now, the clerk, if one of those two people defaults, well, then, of course, the clerk can enter the default judgment. But if you file a case and then the woman files a counterclaim, well, now the clerk doesn't have the authority to act as a judge. So now your case, it actually has
So now what if the defendant goes and tries to hire a lawyer for this? Then what happens?
Then she's actually going to be at a disadvantage because you can make the attorney a defendant.
That's a deep concept, though.
Yeah, that's going a little bit beyond what we're going to discuss here.
You know what? I just got to say, Jan, and you can cut this out if you want, but I love the way you talk shit about your ex-wife covertly like this.
But anyway, what would happen is then the court clerk is going to say, well, your case now needs to be litigated, so it needs to be moved for a hearing. Okay, and that's where another trap gets laid out for you, because that clerk, unless you specifically say, I want to go before a magistrate without the state. Then she's going to put you either in front of a magistrate within the state or in front of a judge within the
And I think this is where the importance of a jury comes into place, because, you know, I always tell people, look, you never really want a judge to decide your fate. You always you know, your best chances are with a jury of your peers. The problem is it's very hard to get a jury of your peers because my peers would certainly not be the average person that signs a form that says they can be called for jury duty. That, you know, my peers would have to be a very select group of people that I could count on my fingers.
Mm-hmm.
So, you know, at this point, when you have to enter back into the litigation process, you have to be very careful. And again, you're always, the only advocate for you is you. An attorney is not going to advocate for you, because an attorney is admittedly an officer of the court, is there in commerce, making a profit from these things, and also there to uphold the rules of procedure of court, not to seek justice for his client necessarily. That is a secondary notion that an attorney, you know, that the job of the attorney, his first job is to uphold the procedures of court, period, end of story. That has nothing to do with the client per se. So the jury, the concept of a jury and a grand jury is so important. That's, of course, another whole other subject. But the point is, you want to avoid the artificiality of these judges as much as possible.
Mm-hmm. Yeah, but you know, the point that we're trying to say here, and the main angle of my purpose with here was not so much to discuss between a man and another man, but just to show that you have a huge advantage when you have a fictional entity coming after you. Now, if you are right.
Let me ask you something, because you have these banks that create money when somebody takes out a loan. And let's say, you know, hypothetically speaking, that you have a foreclosure on your house coming. And is there any way to use this, since it's a fictional character that's filed this foreclosure on you and your home? How would you use that?
Well, actually, I'm preparing right now a default judgment for a court clerk to approve in just that exact scenario.
Wow. And so it just goes to default because the bank can't send anybody to represent them, and then you win, and then the foreclosure is done, right?
Well, because, you know, this same statute says, but his action may be suspended or altered or rescinded by the court upon cause shown. In other words, so can't, once the default judgment is given, doesn't the other party still have the opportunity to counterclaim?
But how would they if it's a fictional character in that court?
Well, that's the question.
Yeah, that's the problem. You know, I mean, the court clerk is operating in the real world under real down-to-earth evidence, and if they're going to try to counter you, they have to bring cause, you know, lawful cause to overturn the decision of that clerk or
the highest court.
Yeah, and I right now I don't see how they can do that.
Well, I think this boils back down to what you've been saying all along, and it's the thing that people miss the most is the importance of the paperwork that you create. Now, I know there's a lot of associations and people out there that are trying to sell the legal documentation of things, and they, you know, basically give you almost a volume, a book full of legal terms, and you have to use red ink for this and black ink and blue ink for that. But the truth is, a legal demand, a legal action like we're talking about, that instigates all of this in the first place, to where the other, you know, the letter that you're sending, that's the most important part, because it has to be done correctly. It has to be very simple and to the point. It doesn't need to be 20,000 pages long, but maybe one or two. And that is what is given. It's notarized, first of all, so you have a witness, and then it is certified so you can guarantee and you absolutely know that the other party or corporation or whatever has received your claim, your notice, your demand, And that is what is given to that's what you want to make sure goes into the court clerk, not the clerk of the courts or all these other Yolandas running around, but the court clerk. And that signifies that it is now on the record, the physical record, not in the artificial world where it might not even ever make it to the record. And that is the most important part. Once you've done that, that is where the real case begins. And if they default on that, that is where, or they don't answer your claim or respond in the proper time, that is where the default judgment comes. And they've just lost the case. And nobody does this.
Yeah.
Nobody does this. This is court without going to court.
Mm-hmm.
It's amazing.
It's actually
so you could do this with any type of loan, student loan, whatever, any type of loan that you have. You could clear it this way.
Yeah, you give them the opportunity to counter you.
Yeah, now I want to say also for the record here that we are talking about concepts that aren't just something you can learn overnight. I mean, we've been studying this, me and Burt especially, have been studying this for years and years now. And, you know, it's not something we're telling people to just go out and write a letter and say, you owe me money. No, that's not what we're saying. You need to do this correctly, and it has to be in the spirit of law, which, natural law, meaning... if you will, God's law. Do no harm to others or their property. You don't just go up to people and give them some debt that you expect them to default on because they don't know what they're doing. This is to protect your rights and to get remedy. But you have to know what you're doing. You have to really understand a lot of this stuff. And for that, you need to do a lot of studying before you try to do this, or, contact someone like Burt, who's actually helping people do this.
And we're by no means instigating fraud or trying to get you to get out of your responsibilities or anything like that.
Of course.
You understand.
Because it's all about being in...
Well, it's like these student loans you take out 15, 20 years ago and you're still paying on them even though you paid off the original amount 10 years ago, right? That kind of thing. It's, even though your corporate entity agreed to those terms originally, you weren't aware of how the whole fraud operated. You weren't fully aware of the how the money was created in the first place.
Heck, I have thought about that because my student loan that I got for my sound engineering school, they recommended that I take the full length of the loan, which was some ridiculous amount of time to pay it off.
That's what I did too. That's what I was recommended as well.
I mean, that's technically legal advice. That's not something that they're in the position that they can provide. I mean, she specifically said. I mean, that's fraud in and of itself.
Well, but I mean, there's we could do a whole show on notes and loans and mortgages, and I mean, I can point out some things that people will be like, damn.
Well, maybe we should think about doing that next week.
Yeah, we could, because right now the two things that are destroying people right now are all these criminal accusations that are actually destroying people's lives, literally destroying people's lives. And the other one is the fact that so many people are losing their homes. Those are the two things that are actually bringing down this country right now.
And people are losing their homes because they are agreeing to the contract that is the offer that is sent to them, the offer to foreclose. It's voluntary. It's amazing when you learn the fraud that is this industry. It's all backed by government and protected by government. It's pathetic.
Mm-hmm. But anyway. I hope that this kind of gives a basic idea of the two courts that are operating simultaneously.
Yeah, and the concept that as with everything, as we've discovered, Burt, everything has a state of being and a state of artificiality. You have arms and you have legal firearms. You have, what was it? You have cannabis sativa and you have marijuana. One is legal, one is just a plant. Arms cannot be regulated, but firearms are legal persons, legal fictions. Everything must have an artificiality in order to be regulated, and that's so important.
That's actually another show on its own, just simply discussing what congressional acts are and how they get them to apply to us by us believing that they're talking about X when they're really talking about Y.
Well, Jan, I want to thank you for doing this spur of the moment, and I really do think it's important for people out there that are armchair, legal scholars that they understand this, and so I wanted to thank you for having us on.
Thank you for bringing it to my attention, and no problem. You're welcome. And like I said, maybe we should do this again in the next week or two and get some more of this stuff out that we just talked about.
Yeah, I just put in there the other website that I have that actually.
Give out your website.
Yeah, you have to put in the www.onlyfreeman.com. Freeman, M-E-N.
Not free man, free men.
Freeman, yeah, freeman.com. And I have a couple of booklets there. Those are the ones that Clint was talking about that I have for people who want to learn what the truth is about arms and firearms. And then
everybody in California there, Jan, since you were part of that whole movement, everybody should have Burt's, and I don't know something like $3.
Yeah.
Everybody should have this research he did on marijuana and cannabis. Basically, it says there's nothing illegal at all. The only reason that these dispensaries, people growing marijuana, are getting in trouble is simply because they are attaching and they are agreeing that it is a legal term. That is the only thing that's getting them in trouble. Everybody's in jail voluntarily because they're admitting to doing something illegal when in fact there's nothing unlawful about what they're doing. And it's I can't stress enough how important that concept is, and he really lays it out in these things, as well as the arms and firearms. Amazing stuff. I mean, you can have a whole cache of guns that are just unregistered guns as arms, and you can literally tell a police officer or anyone that's asking that you own no firearms because they're not registered legally as in the legal realm as firearms. Everything has a straw man, and it's the straw man that is regulated, including us.
So this would be why they're trying to get rid of buying guns at gun shows and things like that, where you don't have to go through their system and register it, because then it's just an arm and not a firearm.
Exactly, and that is the most important topic of the day, if people would just understand that. Mm-hmm. Because, I mean, it's in U.S. code, it specifically says, and I think it's Title 15, I sent that to you the other day, Burt, and they actually specifically state on the record, in law, in U.S. code, that they cannot regulate arms at all. And then it goes on to say how they can regulate firearms.
Yes, they make the distinction very clearly.
I mean, it's incredible. So,
all right, gentlemen, thank you so very much, and have a great day. And